Okay, we're still in the course Labor Law 1, Labor Law Book 1. And we continue with our discussion with prohibited acts of the agency. So to continue, the next prohibited act is to influence or attempt to influence any person or entity not to employ any worker who has not applied for employment through his agency. This is another prohibited act. So it's very clear. Next, to engage in the recruitment or placement of workers in jobs which are harmful to public health or morality or to the dignity of the Republic of the Philippines. So example of this would be the hiring of prostitutes and sending them abroad. Another prohibited act is to obstruct or attempt to obstruct inspection by the Secretary of Labor or his duly authorized representatives. So it is, you should take note that the Secretary of Labor or his duly authorized representatives have the authority or mandate to inspect the offices of agencies which are recruiting and placing workers overseas. Another prohibited act is to fail to file reports on the status of employment, placement of vacancies, or remittance of foreign exchange earnings, separation from jobs, departures, and such other matters or information as may be required by the Secretary of Labor. So the agencies or the recruitment agencies have the obligation to file reports to the Secretary of Labor or to the POAA. And this is about employment, placement vacancies, remittance. If the worker has been separated from his employer overseas, then the agency has the duty to report that to the agency concerned. Then to substitute or alter employment contracts approved and verified by the Department of Labor from the time of actual signing thereof by the parties up to and including the periods of expiration of the same without the approval of the Secretary of Labor. So if the agency will substitute another contract or will alter the employment contract which have been approved and verified by the DOLE, then it is also prohibited. Then there is another prohibited act, which is become an officer or member of the board of any corporation, engaged in travel agency, or to be engaged directly or indirectly in the management of a travel agency. For the information of the students, the travel agency has been prohibited to conduct recruitment or placement of workers overseas. So that is why no agency or no person who is engaged in recruitment must be a part, directly or indirectly, in the management of a travel agency. Then we have another prohibited act, which is to withhold or deny travel documents from the applicant or the workers before departure for monetary or financial considerations. So if the agency will withhold the travel documents to the workers, because he wants more money to be paid to him, then that is a prohibited act. Then failure to actually deploy without valid reason as determined by the DOLI. So you just recruit and recruit without even deploying them, the workers, to overseas. You know? Then there is a failure to reimburse expenses incurred by the worker in connection with his documentation and processing for purposes of deployment. So when is the agency, recruitment agency, liable to reimburse expenses or cost of expenses? This is in case where deployment does not actually take place and the worker has no fault. No? So meaning the worker has already submitted everything, all documents have been complied with, all requirements, but still the worker was not deployed to a foreign country. So this is the fault of the agency or the principal or the employer abroad. So in this case, the agency should reimburse expenses that the worker has incurred. All right. So there is illegal recruitment, which carries a heavier penalty of lifetime imprisonment. So if a person is found guilty of committing the crime of illegal recruitment involving economic sabotage, then he would be imprisoned for his entire life. So what are these illegal recruitment? So there are different types of illegal recruitment. The first one is simple illegal recruitment, which only is a minimum of 6 years or maybe less than 6 years imprisonment. But illegal recruitment involving economic sabotage is a lifetime imprisonment. And this is committed by a syndicate, meaning it is carried out by a group of 3 or more persons conspiring or confederating with one another. And they are carrying out unlawful or illegal transaction, enterprise, or scheme falling under illegal recruitment. So they're probably are without any license, or they're committing prohibited acts, and there are 3 in their office. They're confederating, conspiring with one another. And the victim here, regardless of the victim, could be 1, 2, or more. No? So if there is only one victim, but the illegal recruitment is committed by a syndicate, then if found guilty, the members of that syndicate will be imprisoned for life. And there's another illegal recruitment for economic sabotage when it is committed in large scale. This is a second type of illegal recruitment involving economic sabotage. Now, when is this committed? This is committed if the illegal recruitment was made against 3 or more persons individually or as a group. So if a person has committed illegal recruitment, he has performed the prohibited acts which we earlier enumerated, or without a license, and he has victimized at least 3 persons or more than 3, whether individually or as a group, then he will be liable for illegal recruitment involving economic sabotage, and the imprisonment is lifetime imprisonment. Okay, now let's go to prescriptive periods. Prescriptive periods here means that after a lapse of time, the right to file action against the violators or the criminals will expire. No? So if a person who's victimized, there is a period of time in order to file an action against the violators of the law. So prescriptive period for simple illegal recruitment, IR is illegal recruitment, is 5 years. So if the victim has not filed a case against the illegal recruiter, an illegal recruiter for more than 5 years already, then the victim can no longer file an action against this person because it has already prescribed or expired. On the other hand, illegal recruitment involving economic sabotage, the prescription period is 20 years. So if the victim has been, if the victim should file an action against illegal recruiters which are performed by a syndicate or who are guilty of in large scale, no? Within a period of 20 years. So this time around, it's longer, no? Because the imprisonment here is more than 20 years. That's life imprisonment because this one is a special law. Okay, as far as the entities who are authorized to engage recruitment and placement, there are also a limitation. No? So these are the public employment offices like the DOLI, the POEA, which is the Philippine Overseas Employment Administration, private recruitment entities. So this time it's the private. So it could be a regular Filipino citizen or a foreigner. You know? Private employment agencies. So sometimes there are private recruitment entities owned by foreigners like Turkish who are already residents here in the Philippines. So, and then we have shipping or mining agents or representatives and such other persons or entities as may be authorized by the Secretary of Labor. Construction contractors can also recruit and place workers overseas. So entity who is not authorized to engage in recruitment is a travel agency, including airlines. No, airlines are not allowed. Okay. So question, is direct hiring of OFWs allowed? What do you mean by direct hiring? It means that the company or the employer who is a foreign national will directly come here in the Philippines to look for employees. I will cite an example. For example, Google. Google is an international, is a US company. No? Representatives from Google USA will come here and they will conduct interviews or examinations for qualified applicants. So they are directly hiring, performing direct hiring and interviewing Filipinos. Is that allowed? The answer is no. Foreign employers cannot directly hire workers for overseas employment. And that would be only through authorized entities which are mentioned here. These entities, there's 7 of them. These are the only allowed entities who can recruit and place workers abroad. Now, how much is the overseas worker or applicant going to pay the agency? So, according to the law, no worker shall be charged with any fee until employee obtained work through recruiter's efforts, and the worker has actually commenced working. So, meaning that the worker will still has no obligation to pay the agency or the recruiter until such time that the worker has already flown to the destination country and has actually commenced working. And how much would be the placement fee? Placement fee in an amount equivalent to 1 month's salary of the worker and plus documentation costs. These are the only authorized payments that may be collected from a hired worker. So 1 month salary plus documentation costs. Any excess of this would be a prohibited act and would constitute illegal recruitment. In the case of Eastern Assurance and Surety Corporation versus Secretary of Labor, the POAA, the Supreme Court has said that POAA has the power to order refund of illegally collected fees. The POAA has the power to regulate the recruitment and placement activities of all agencies, including to award of appropriate relief to the victims of the offenses committed by an agency or a contractor. Such relief includes the refund of such fees as may have been fraudulently or illegally collected, or such money, goods, or services imposed and accepted in excess of what is prescribed by law. So this is a landmark case decided by the Supreme Court. So we go to the topic of the nature of the liability of local recruitment agency and the foreign principal. So the foreign principal is the employer abroad, and the purpose of surety bond. Okay, a local recruitment agency liability is solidarily with his foreign principal. So meaning solidarily, meaning if the foreign principal cannot pay, then the local recruitment agency will be liable. No, so that is solidarily liable. For what? For unpaid salaries of a worker that it has recruited for overseas work. Okay. How about if the local recruitment agency has already severed ties with the foreign principal, meaning they have already cut off ties, the agency and the principal, they're not in good terms anymore. Will this solidarily liable also be severed? So the answer is no. It's given here that even if the relationship between the local agent and the foreign principal has already been cut or severed, it does not affect their liability, especially of the local recruiter, for any violation committed by the principal against the employment contract. For as long as no notice of the agency agreement's termination was given to the employee. So if ever your business is local recruitment agency and you have severed ties with the foreign principal or companies abroad, you should notify the employees that you have successfully recruited for this foreign principal. Why? In order to avoid liability in case the foreign principal will not pay the workers' salaries. No? What about the surety bond? What is that? It's like a guarantee. Who's, who is providing this guarantee is the surety company. It's like an insurance, no? So here we have a case, Stronghold Insurance Company versus Court of Appeals. This was decided in 1992 by the Supreme Court. The Supreme Court says that the surety bond required of recruitment agencies is intended for the purpose or for the protection of the Filipino overseas workers and hired by foreign companies. The purpose is to ensure that if the rights of these workers are violated by their employers, recourse would still be available to them against the local agencies that recruited them for the foreign principal. The foreign principal is outside the jurisdiction of our courts and would probably have no properties in our country against which an adverse judgment can be enforced. This difficulty is corrected by the bond or the surety bond, which can be proceeded against to satisfy that judgment. So uh, before a local recruitment agency can transact or recruit and place workers abroad, they are required to place a surety bond in order that if there are claims against the principal or foreign principals, then the surety bond will answer for any of the liabilities. Okay, now we go to the topic, employment of aliens. Meaning aliens will, when are aliens or foreigners hired or be working here in the Philippines? No? Okay, are there requisites to follow when we hire aliens for work here in the Philippines? Yes. The first requisite is a working permit. This is permit from the Department of Labor. So the alien before working must obtain a working permit and certification uh, from the employer that no Filipino is willing and competent to do the job for the employer. And then the number 3, the alien must train at least 2 Filipino understudies for such undertaking, meaning that if ever these 2 Filipino understudies will be competent enough to replace him, then the alien will stop working and the understudies will replace him. And number 4, for enterprises registered in preferred areas of investment, employment permit issued upon recommendation of government agency charged with the supervision of this registered enterprise is required. No? Are there instances when exemption from permit happens? Yes. When are these? When the aliens are working in diplomatic services or in foreign government offices who are accredited with the Philippine government. Now, who are these? This is like the Japan embassy in Manila. Their workers there are Japanese, of course. So these Japanese need not secure working permit from the DOLI. No? And other foreign government offices. And then number 2, we have international organizations with which the Philippines is a member. An example of this would be the ADB or the Asian Development Bank, the IRRI, the International Rice Research Institute in Los Baños. So the ADB is a a foreign bank, but all Asian nations are member of this. Well, not all, but I think around 90% of Asian countries are member of this development bank, including the Philippines. So if they hire foreign nationals to work here in Manila, then they are exempted from securing work permit. And also number three, missionaries actually engage in missionary work, like priests from Vatican or Baptist pastors from the USA. They can come here and need not secure working permit from the DOLI. All aliens granted exemption by special laws, and those whose employment in the Philippines have been determined by the Secretary of Labor to be beneficial to national interest may not secure work permit. Okay, so the validity of a work permit is for 1 year from date of issuance, unless it is sooner revoked by the Secretary of Labor. It is subject to renewal upon showing of good cause, and it is not transferable. This is not updated because the permit could be 1 year, 2 years, or 3 years. Maximum is 3 years. No? Other provisions: aliens shall not transfer to another job while he has a work permit, because the work permit will show there that he is employed by this company. And if he transferred to another job, then his employer will be another company. So that is a violation. No? It should be, if he moves to another employer, there should be a prior approval by the Secretary of Labor. Another, non-resident alien are prohibited in taking up employment, another kind of employment, in violation of the labor code. So what is stated there in his work permit, if he's only, let's say, if he's a chef, he cannot take another kind of employment, like being a manager in a hotel. So being manager in a hotel is different from a chef. So he cannot take that kind of employment. That would be a prohibition.